Well, let's look at another hot topic these days. Actually, the new retaliation standard that we got in 2006 is without a doubt one of the most controversial and hottest topics going in employment law today. Here's basically what's going on. You got Sheila White down in Tennessee who applies for a job with Burlington Northern Railroad. Well, she doesn't have any experience with the railroad. She doesn't have any forklift experience, and she's applying for a forklift job. So what in the world makes her qualified to work on the railroad? Well, she's cute. She's cute. All right, so everybody out there that studies real hard for your degrees and your education, didn't you know that the main thing is to be successful in America is that you're cute? Obviously, I hope you pick up on the deep sarcasm here. So she gets hired, and she gets hired because the supervisor now has somebody to sexually harass. Well, it isn't long after she starts working there that the supervisor does start sexually harassing her, and she's a 21st century woman. She knows her rights. She goes down and complains to the manager of the railroad yard. Well, the manager looks into it, and he's kind of appalled. He's, oh my gosh, what kind of sophomoric stuff is going on out here? So the manager disciplines the supervisor, takes care of the situation. He effectively deals with it. He then takes a look at Sheila White and says, no, wait a minute. She was hired for this forklift position, and she's not qualified. What is she doing on a forklift? So he says, we can't have this. So he demotes Sheila White and takes her off the forklift and puts her in the railroad yard. Well, she gets really upset over that. She says, this is retaliation, and I was sexually harassed, so I'm filing a charge with the EEOC. Well, you see, now at this point, it's questionable as to whether or not Burlington Northern Railroad retaliated against her. And they did deal with it, with the harassment, as soon as it occurred. You see, she wasn't qualified to run the forklift. She had no experience. She never should have been hired in the first place. So there's a very good argument that the supervisor, or the manager, I should say, is correcting a situation that never should have occurred. But Sheila White has a point too. I would have never been demoted but for me reporting this. So you kind of got this standoff going here. Well, it's kind of all a moot point because as soon as the manager of the railroad yard discovers that Sheila White has filed a charge against them, he fires her. Well, that's pretty much retaliation there, isn't it? Now, she's fired, and this is actually over the holidays, right, over Christmas. So she goes home, unemployed, probably tremendously worried over what am I going to do now? I'm out of a job. It's Christmas, all this kind of stuff. She's got kids. Now, picture the paperwork. This all happened down in Tennessee, and the paperwork is going to make its way slowly but surely all the way to corporate headquarters of Burlington Northern Railroad. Now, could you just imagine being the human resource person sitting there, or the in-house counsel sitting there when this paperwork comes across? I mean, you probably swallowed your tonsils at that point. You just can't believe that you got a manager that would do something so god-awful stupid. I mean, we're sticking 3 forks and a finger in the outlet now. So they get on a plane, fly down to Tennessee, and they fix everything. They bring Sheila White back. They give her back pay. They give her the forklift position. They train her in it. They apologize up one side and down the other. Sheila White said, not good enough. And she continued to sue them. Well, Burlington Northern Railroad is like, no, wait a minute, there's no retaliation. We fixed everything. At that time, retaliation was defined as being some kind of tangible harm against the employee. And that's what Burlington Railroad defended itself on. It went all the way to the United States Supreme Court in 2006, and it's in front of the court, and it's saying, we fixed everything. These things happen, we fixed it. Sheila White had a more novel argument. Here's her argument. She said, basically, I have been subjected to an environment that would dissuade people from wanting to speak up. So you see, I agree there has been no tangible harm. Burlington Railroad fixed that. However, they have created now an environment that would dissuade the reasonable worker from speaking up. And she had some authority from the EEOC. The EEOC had materials that supported that. It wasn't law. It was just enforcement guidelines from the EEOC. But the United States Supreme Court looked at this and they agreed with her. They said, yes, you have fixed the tangible harm. Congratulations. That's great. But the Supreme Court held that a plaintiff must demonstrate that he or she suffered a materially adverse retaliatory action, which could include creating an environment that well might have dissuaded a reasonable worker from making or supporting a charge of discrimination. And the logic of the United States Supreme Court is very clear here. We do not want employers creating environments where people won't speak up. And if you kind of look at what Burlington Railroad did, all the other employees are sitting around watching what happened to Sheila White. Well, yeah, that's gonna dissuade anybody from speaking up, because they're gonna say, hey, I'm not gonna say anything. Did you see what happened to Sheila White? Man, I'm not gonna complain about anything. Now look at this standard. Have we created an environment that would dissuade a reasonable worker from making or supporting a charge of discrimination? That's not a real high standard, folks. Are you dissuading people? It's not like you're preventing them. It's not like you're forbidding them. But you're creating an environment that would dissuade people from speaking up. People that are afraid to speak up in the first place, in most instances. This is the new retaliation standard. Now, you still got the standard that we talked about with tangible harm. You fire somebody, you demote somebody, you cut their pay. That is still retaliation. Don't get me wrong. That is retaliation. But now you've got this additional standard. Are you creating an environment that could dissuade someone from speaking up? That is not a very high standard. Intimidation, threats, those types of things, you don't have to touch any tangible aspect of an employee's job anymore. You just create the environment that would dissuade other people. This you need to keep your eye on. Someone files a charge, and I mean filing a charge not just with the EEOC, but they are filing an internal complaint. They have protection. They have protection. You better treat the employee the same as you have been treating the employee up to that point. Otherwise, that could be seen as retaliation, because now you're dissuading that person from wanting to speak up.